Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Some news from the Supreme Court on Monday. The justices agreed to hear a case challenging so-called Chevron Deference. This is a judicial approach that says that there should be deference to regulators who are interpreting ambiguous laws. The case that the court agreed to hear probably in the fall is called Loper Bright Enterprises v. Raimondo. And Alicia, can you give us a sense of what are the facts of this case and how big of a deal it would be to challenge Chevron deference in the sort of administrative state that the U.S. now has?
So this is a very kind of abstruse case, and I don't think it was actually on a lot of people's radar. It challenges the 2020 regulations. So this was actually issued under the Trump administration, under a 1976 fishing law known as the Magnuson-Stevens Act, that essentially sets out all kinds of requirements and regulations for fisheries and how they may operate and such. And the law allows the National Marine Fisheries Service to require fishing vessels to carry federal observers, so basically regulators, on board to enforce the other regulations under the law. And in a few narrow circumstances, it also allows the agency to require vessels to pay for the salaries of these government monitors. But in this case, in February 2020, again, this was actually under the Trump administration, the agency went even further and required some of these vessels operating in the Atlantic that weren't covered by these narrow circumstances to foot the bill for the government monitors. And I think the agency even estimated that it would cost the fishermen about 20% of their annual revenue. So this is very significant. You had about 4 family-owned and operated fishing companies. These were, as it happens, they're herring fishermen, sued, and they argued that the law did not authorize the mandate and that there was no explicit authority in the law to do this. In its defense, the agency cited a catch-all provision that allows it to, quote-unquote, prescribe such other measures, requirements, or conditions and restrictions as are determined to be necessary and appropriate for the conservation and management of the fishery. You can note that a lot of laws have these kind of catch-all provisions that allow agencies to do whatever are necessary or appropriate. I think the law that the CDC has often cited for its emergency powers has such a catch-all provision. And the D.C. Circuit, is a divided D.C. Circuit panel, upheld the government's broad interpretation as quote-unquote reasonable because it was not expressly precluded by the law. And you see this happening again and again in a lot of cases wherever a law doesn't expressly forbid the government from doing something, the government will argue that it can do it, and the judges often defer to that, and that is what it's known as Chevron Deference. This is a 1984 court case and precedent that it essentially set out a framework for judges to determine whether even to defer to a regulator's judge or interpretation of a statutory authority. And it's been challenged. The Chevron Deference has been challenged indirectly in a number of cases in recent years. I think I wrote about one a couple years ago involving reimbursement rule under HHS. Again, that was actually issued by the Trump administration. But this is actually a head-on frontal assault on Chevron deference. So this should get interesting because there is the potential for the government or for the Supreme Court to overrule the Chevron and actually kind of restore judges' abilities to actually say what the law is.
And on that point, I would note one thing that I think is interesting in this petition. So when a case goes to the Supreme Court, there's a petition for writ of certiorari that is filed. And this one says there are 2 questions presented. One is whether this case includes a proper application of Chevron. And number 2 is whether the court should overrule Chevron or clarify it. And then the Supreme Court's order list, which came out on Monday, says the petition for a writ of certiorari is granted limited to question 2. And so they are not even taking the question of whether this case was Chevron properly applied. They are only taking the question about overruling or clarifying it. And I guess that is not a huge surprise. There are some members of the court who have been very critical for a long time of this kind of deference to administrative agencies. And I'm thinking specifically of Justice Neil Gorsuch. I recall that when he was confirmed, one of the opinions that was floating around that he had written as a appeals judge was talking about these different sorts of deference to administrative agencies that the judiciary has set up. One of them, this one he was complaining about, brand X deference, that's named after a different case, requires the court to defer to the agency's policy choice, even when doing so means we must overrule our own pre-existing and governing statutory interpretation. And basically he says that there are some occasions when a federal bureaucracy can overrule a judicial decision. And Kim, the point here, the basic point here, is one of independent judgment. The judiciary, I think Justice Gorsuch would say, and possibly the majority will say here with regards to Chevron, that the point of having judges look at this stuff is to decide what the law means. And if they abdicate that and give that authority over to these regulatory agencies, even if it requires some sort of step of finding the law ambiguous, that ends up giving all sorts of power to the executive branch that it's not really meant to have. You have any sort of law that you can construe as not clear, and I think it shouldn't mean that the administrative agency can decide how it wants to apply it.
Absolutely. If you can draw a straight line from that Chevron decision and the rise of the all-powerful administrative state, and it's grown even greater on display as that bureaucracy has felt more and more unleashed, untethered, and taking more and more liberties with the decisions that they make. That's why this case is just so great, and why I was excited about it even when we wrote about it in December when they filed the cert petition. I mean, one of them is the fact that in this Fisheries Act, there are very specific defined places where Congress decided to allow the National Fisheries Service to force vessel owners to pay for these federal monitors. Very specific cases. One of them is for certain foreign vessels. Another, which I think is notable, is those that operate in the North Pacific Council region, which are places like Oregon and Washington and Alaska that have some of the largest, most commercially successful fishing operations, where Congress had clearly thought this through and decided that they could afford to have such a federal monitor. In this case, the contrast is amazing. I mean, here are these poor little herring fishermen with their small business operations, understand that these boats that they run on hold maybe like 5 people at most. The estimates by NMFS, their own calculations, that this could cost up to $710 a day, which is more than usually the captain makes, and even if they're having a good day out on the boat. And remember, this is an industry with very small margins, so this is essentially a death knell for a certain number of small fishermen that are affected by this ruling. And if you read the lower court judge's opinion on this too, which found for the fishermen, he just makes some other really great points, which is really we're not going to have anything that Congress didn't think to put into a bill and say you cannot do this, that now the administrative state gets to take his license to do it. That could end up with some pretty crazy outcomes. And also he made the point that, the problem with this as well too is there's no limiting principle. If you are going to allow the administrative state to say we can use this catch-all phrase to force these fishermen to pay for these monitors, why can't you also force them to drive those monitors back and forth to their office? Why can't you force them to pay for certain things that the monitors need on the boat, or that the monitors need as part of what they need to do their job? I mean, that's a very sort of scary idea that just some people sitting around in a fisheries office in Washington get to come up with this stuff, and nobody is there to say no. So I think that as cases go, this is probably one of the best they could have chosen to tee up this question of whether or not you overturn Chevron.
Thank you, Kim and Alicia. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.